Good morning. Good morning, everybody. Welcome to the 2021 Sherman and Howard Construction Seminar. Thanks, everybody, for being here in our hopefully once only virtual format. We are going to do the construction seminar this year virtually, as you can all see. We are going to stay with our normal format, which is our rapid fire format, though to avoid ultimate Zoom fatigue, we are going to focus on 2 hours instead of our normal 4 hours. Otherwise, we're the same. We really thank everybody for joining us today. We really appreciate everybody coming online, spending more time with us online, and we hope this is useful time for you. Before we get started, I wanted to address a few of the functionalities of the format we're using. You see 4 pods in front of you. They are fully adjustable to your specific desires. What that means is you can move them around, you can make them smaller or bigger, whichever one you want to look at. If you want to make the slides larger or smaller, you can, the video, the Q&A, any of them. There's a little green dot at the bottom if you ever want to reset and bring them back to the standard format. Let me tell you about a few of them. The Q&A on the bottom, that is going to be live at any time. We ask if you have questions as you go, put them in there. As you know, in our format, we don't do questions during this presentations themselves. Typically, we're going to do a Q&A after each of our 2-4 sessions. So please write your questions in there. I'll be reviewing the questions. And then during our Q&A, I hope to be able to get to everybody's questions. I may not be able to, but we'll make sure we get back to you if we can't answer your questions during the Q&A session. Then there's the handouts pod that has all the handouts that you can download for your use, as well as CLE accreditation if you need it. And if you're an insurance professional who needs insurance accreditation, please email your license number to our team at events@shermanandhoward.com, and they will take care of you. I'd like to now move directly into the presentation. I am your first presenter, so you get more of me. So let me get started. First topic we'll be discussing today is current issues in construction contract negotiations. So let's talk through those. First, biggest one that everybody's aware of and has dealt with, COVID-19. I'm going to address I obviously won't be able to address everything in terms of various contract terms, various types of contracts, and from every perspective. I'm going to try to hit things at the highest level for you. These are some of the issues we have seen in the past year from COVID-19 that we've been addressing with our clients, not just in terms of the issues, but as well as the contract terms, and I'll walk through that next. First, government shutdowns. That's something that happened a lot in the beginning. It hasn't happened recently, at least for the construction industry, but it is still a prevalent danger out there that could happen in terms of a complete shutdown, a partial shutdown, or some kind of impact shutdown. Health and safety regulatory compliance. That is a big issue, something that's always been in contracts, but is obviously very important in terms of COVID-19. What happens if your team gets sick? What happens if there's a change in staff? That's an important issue. That's an ongoing problem that isn't obviously going away anytime soon. And then delays, also something that's not going away anytime soon. Subcontractor delays, supplier delays, shipping delays is something we've seen a lot. Labor delays. Those are all issues that we've been dealing with, and we'll talk about how some of the contract terms you can deal with. So COVID-19 contract terms, shutdowns. It's important to identify who has the risk associated with a shutdown. In the contracts that were in play prior to COVID-19, that risk typically fell on the owner, but depending on the language, it could have been in a force majeure provision. Remember your force majeure provisions, because people look at them as if they are standard, and there is some standard language, but they can change. Both what is in and, importantly, what is not a force majeure can heavily be changed and negotiated in a contract term, and COVID-19 is a prime example. Many people try to stuff something in a force majeure provision, which alleviates the risk from both sides, but it doesn't fit. It doesn't always fit, not how many of the contracts are written. Second issue is regulatory compliance. From a regulatory compliance perspective, it typically falls on contractor and subcontractors to make sure they're in full compliance with any regulations. Now, COVID-19 has added from many health departments significant additional requirements that need to be met. The problem you see is a lot of contractors need to keep up with the schedule. A lot of subcontractors need to keep up on the schedule. And full regulatory compliance is expensive. People are trying to do it, doing their best, but enforcement, I will say, in my experience, is haphazard, both from a contractor, subcontractor, but also from a regulatory enforcement. That may change. We don't know. So having the contract terms associated with that and identifying how it will be dealt with are important. Indemnification. What happens if lawsuits come out a year or two from now of people who are getting sick or damage or something associated with while they were at work? COVID-19 is something that is new, but that type of indemnification is typically governed by your standard provisions of the contract, but you should review them carefully. Staff changes. As I mentioned, what happens if your team gets sick? I've had a number of clients who either themselves, through their team or their subcontractors, or from the owner's perspective, an entire team gets sick, meaning all supervisory personnel or a group of labor associated with a certain subcontractor. How that is dealt with in terms of both a delay, a cost increase, and responsibility are important terms to address in your contract. Delays, as I mentioned. Typically, a COVID-19 delay would be, depending on how the contract term was written prior to COVID-19 coming in, an excusable delay and a compensable delay. That it doesn't have to be that way. Obviously, the delay provision is one of the most heavily negotiated provisions in a contract. So everybody should make sure that they have addressed those provisions and don't just assume that the standard provisions you have relating to delay or that you expect or reasonably expect to see from the other side are going to cover it or address whether it's compensable. It's not unreasonable to say that it's excusable but not compensable. Those are terms that could be negotiated and addressed between the parties. Cost increases. You have seen, and we've all seen, significant cost increases associated with issues related to COVID-19 and other matters. How are those addressed? There's a number of different circumstances within the contract that can address it, the contingency and which contingency, whether it's an owner contingency item, a contractor contingency item, what types of mitigation efforts can and should be taken and who has responsibility for those, and how the risk will be shared amongst the parties. Oftentimes, as I said, the prior contract provisions address that risk on the owner if it's a shutdown. But otherwise, for example, if a subcontractor just can't get his labor on there or his labor gets sick, that's on the subcontractor or a contractor. So that's something to look at and consider how the risk is bared. All right. Going away from COVID-19 now, which I'm sure we're all happy to do, but we're not there yet. Design responsibility. These are some of the key issues that I've been seeing and we've been seeing in contract negotiations and on projects, and important items that everybody should address with their contracts and with their negotiations. Incomplete design is a first design issue that we are seeing a significant amount. I'd have to say, in my experience, I think this comes from the fallout from 2008. 2008, when that market crash occurred, many designers lost their jobs. I think at one point in time, it was 90% of architects who were out of work. Now, so in the past 6-7 years, with construction significantly ramping up, designers are taking every work they can, saying yes to everything, and in my opinion, not completing the design in many cases accurately and completely. We're seeing a lot of attempts to move that design responsibility, or what is typically the design team's responsibility, onto owners or contractors. An example of that is coordination. And I don't mean coordinating the work here. We are seeing basically a trend in the industry among the design professionals to put coordination of the design items onto the contractor, or attempts to do that, and or the owner. And some of these depend on the contract terms. I have seen contracts that actually don't put that, and it specifically excludes coordination from the architect's agreement, and others that clearly would have it, which is a typical architect requirement. So design coordination amongst the different design professionals and the design team is an important item to watch out for. What is reasonably inferable? Most construction contracts have a reasonably inferable language. What does that mean? We typically make efforts to define that slightly further to the extent that language stays in, which it typically does in some form or another. And so we make sure that people identify that as best we can. It is often a highly contested contract term negotiation, so pay attention to it. And then the contractor's contingency. We are seeing a lot of efforts from owners to to control the contractor's contingency in some way or another, either how it can be used, what it should be used for, and in many respects to try to use contractor's contingency for design issues. And that's why I put that under design responsibility. Government matters, tariffs. This is something that's been around for the last 4 years. It has creeped up. It isn't going away. It's one of the reasons I mentioned it. The tariffs haven't gone away. The change in administration is not making the tariffs go away completely, so everybody should be ready for it. What about threatened tariffs is a very important issue to be considered when you're negotiating the contract. Try to make sure the contract terms identify what tariffs are included, what's not. Code enforcement changes. We are seeing a lot of, and have seen in the last 4 or 5 years, code enforcement changes from local government agencies who enforce it. So make sure you're paying attention to that, including issues relating to innovative designs or phasing of projects. If you're making those, if you have anything involved phasing or innovative design, make sure you consider what impact it would have if the government, regulatory agency, local government, code enforcement, fire department might change how they do things. And the assumptions you're relying on for standard procedure, for example, a fire department might use. There's been many claims when they have not followed standard procedure, have modified their enforcement mechanisms during the course of the project, and that changes the impact of how either it can be built or can be completed. Risk allocation. One of the issues is caps on liquidated damages is a constant term now. Liquidated damages are in nearly all construction contracts, and a cap on liquidated damages is a way to balance the risk associated with that. Contingency, again, what can it be used for and who controls it? That is a hot issue now in our contract negotiations from both sides, and how it can be dealt with. In the end, what I mentioned to you is be careful. You want to work together with your teams. What do I mean by that? Not just with contract negotiation, but in terms of finishing the project. Work together to actually discuss what these terms mean. Make sure you understand that the contract terms you're using will actually be consistent with how you expect the project to be built, not just using a contract term that is from some form that doesn't fit within it. Choose your contracting partners carefully. This is obviously a broad spectrum warning to everybody, but some of the problems are people are just desperate for work or want the work and let their typical, uncomfortableness with somebody go away. And I would say, is it worth the risk? And that's something for everybody to consider on both sides. If it saves you a few bucks, but if it causes you a lot of pain down the way, you have to decide if that's worth the risk. And lastly, get help from experienced counsel. We're here to help you, or if you have other counsel, make sure you use them. These contract negotiations matter, and the contract terms do matter. Thank you again for your time today. I will be coming back on to moderate the Q&A sessions. I appreciate your time, and thank you everybody for joining us. Let me next introduce our speaker, who is following me, Stephen Hess, who we affectionately refer to as the professor.
Thank you very much, Tamir. Good morning, everybody. I was going to talk about recent court decisions, but in the span of 12 minutes, I can't cover a lot of what's happened within the courts. But the most spectacular case that I want to address is a case that I would like to introduce with a picture of Grace Kelly. I'm not actually sure what's up on the screen, and I apologize for that, the way this works. Grace Kelly, a year before she married Prince Rainier of Monaco, starred in a movie, To Catch a Thief. And that's what we're going to talk about today, to catch a thief on construction projects. The Colorado Trust Fund statute, which surprising to me, not everybody knows about, says if you're a contractor or a subcontractor and you get paid money You have an obligation to put all that money into a cookie jar for the benefit of people that you have retained as subcontractors, sub-subcontractors, material men, laborers, or anyone else who might have a lien on the job. And if you take money out of that cookie jar and pay yourself before you pay the people under you, you are a thief, literally. By definition, violation of the Colorado Trust Fund statute constitutes theft. And we'll talk about why theft is a problem, not just in the criminal sense. Very, very few people get prosecuted for violating the trust fund statute, even though it does constitute criminal theft. It has very substantial civil penalties, and that's what we're going to talk about. Now, those of you who have been here in past years would say, Hess, you've talked about this before, you're beating a dead horse. This is Dead Horse Point State Park. It's the best visual I could get. I didn't have rights to use anything from The Godfather, but think about this Dead Horse Point. This is not a dead horse. This horse, I'm sorry to say, is alive and well. I currently have 3 cases worth over $1 million with trust fund claims in them. And those trust fund claims are going to dominate, and you'll see why. Let me give you the facts of a case that just wound up in December. Nomad Excavating was a subcontractor to Bassett on a City of Aurora construction project. So City of Aurora hired Bassett. Bassett hired Nomad Excavating, and Kenneth McGill is the president of Nomad. And you'll see why identity of the president is something that's important in this tale of woe. Nomad hired JK Transports to do a modest amount of work, $12,142 worth of work specifically. And then it didn't pay. And part of the reason it didn't pay is that City of Aurora through Bassett had paid maybe $70,000 or $80,000 to Nomad, but before Nomad hired JK, it had spent that money. Then it hired JK. And after it hired JK, it didn't have but $8,000 left, and it elected not to pay Nomad. What happened? You can see bad news. This is an emoticon. I mean, there was a day when we used to write things out or just use words like no, but now our kids learn lessons like how to use emoticons or emojis or whatever they're called. In any event, the question the court had to answer first was, out of this $12,100 or so, Bassett actually ended up paying the subcontractor. And so the first defense that Nomad asserted was, well, wait a minute. JK Transports actually collected the $12,000. Why are they suing us for theft? They didn't lose anything. And that's when the court said the answer to that is you're wrong. The fact that ultimately somebody else paid this debt for you doesn't mean that the money wasn't stolen in the first place. And so the individual and the company, Nomad, asserted a second defense. And the second defense is what's really important in this day and age, because this issue has not been articulated nearly as clearly in Colorado court cases as it was in this bankruptcy case. And this bankruptcy decision, by the way, was just handed down on December 7th. The second defense was, well, by the time that JK performed the $12,000 worth of work, Nomad said, we had been paid. And after we got paid, we had spent the money, some of it on ourselves, some of it on other people, but there was no point after we hired Nomad where we got no money in. That is, there was no more money that somebody put into the cookie jar that we could be accused of having stolen. And the court's response to that, and you can guess what it was because we're spending a lot of time talking about that case today, was to laugh. The court said, that's not right. It doesn't matter. You always have an obligation with regard to the trust funds to hold them. This is the court laughing. It took me a while to get to this slide. But the court just laughed that off and said, you have to treat all of the income that comes in on a job as a single pot of money, and the timing doesn't matter. That issue actually wasn't clear until December. This is a bankruptcy court case. This will get litigated again, but you don't want to be the person against whom it gets litigated. And so what happens when there's a theft of trust funds? That is, what happens when you get income on a job and you fail to pay downstream subcontractors? Well, under the trust fund statute, there are several ramifications. And you'll see the ultimate award in this case sets it out in pretty dramatic terms. The first thing is that there are treble damages, meaning that instead of merely owing the $12,000, the person who steals from the trust fund owes 3 times that amount. The second ramification is that this is one of the rare instances in which somebody who wins a lawsuit without a contract for attorney's fees is actually allowed to recover attorney's fees as well. And the attorney's fees in this case were as much as the treble damages. The next and most profound impact is this was not just a lawsuit against Nomad. This was a bankruptcy non-dischargeability action against its president, Kenneth McGill. A debt under the trust fund statute is non-dischargeable in bankruptcy. And so what started out as a routine $12,000 contract debt of a corporation was turned into a $72,000 debt of the individual who was responsible for directing the money. And that $72,000 debt doesn't even include the $20,000 or $30,000 that Mr. McGill spent to defend the action through his own counsel. That means what is ordinarily a relatively innocuous $12,000 corporate debt suddenly became a $100,000 personal debt that would never, ever go away. The lesson from this story is what I've mentioned before, and that is don't get caught with your hand in the cookie jar. If you take money that is intended or even not necessarily intended for lower stream subs, usually the owner doesn't know specifically who money's intended for. But if you get money on a construction project, it needs to stay in the cookie jar until all of your subcontractors, materialmen, and laborers have been paid off. If you're the individual at a company who is responsible for directing where money goes, and you do not ensure that the income goes first to your subcontractors and to your materialmen and to your laborers, you face that horrible prospect. Not the crime itself, but the civil ramifications of civil theft, treble damages, attorney's fees, yours, together with the opposing parties, and non-dischargeability in bankruptcy. And so I've mentioned this before, and I keep hoping that someday there aren't going to be any new fascinating cases to demonstrate, and we'll talk about something more boring like the economic loss rule. But this year, just last December, we got a startling example of the trust fund statute. Thank you for your time today. Our next speaker is Mary Sue Greenleaf, who is one of our associates. On occasion, I try to mentor our associates by sitting down with them, or in this day and age, it's virtual. I had a discussion with her yesterday about dealing with reservation of rights letters and advising clients when insurance counsel step in to defend a claim. And in the true Socratic method, I asked her first, why don't you tell me your thoughts? So then I could riddle her with questions. Well, 15 minutes later, she had given me a well-organized, thorough, legally mature, and completely adequate response. I had nothing to teach her. Of course, I couldn't tell her that. I told her I had another conference call coming in. In any event, Ms. Greenleaf, take it away.
Thanks, Stephen. I get to talk about everybody's favorite topic today. I have the pleasure of speaking with you about claims and litigation. Because the subject is such a fun one, I thought I would kick us off with a quote that I think pretty much sums up the general attitude and feeling that most of you all probably have about the prospect of litigation, and that truthfully, many of us litigators also have about the process. Litigation, a machine in which you go into as a pig and come out as a sausage. So obviously the quote is a joke, but starting off a pretty serious topic that most of you probably don't want to hear a lot about, I thought it was actually a painfully accurate description of what the process can be like. It's expensive and time consuming, and despite the possibility of a favorable outcome at the end of the day, no one really wins. It distracts and diverts your resources from the actual work that you're doing, could tie up some of your most valuable team members as they struggle to go back through hundreds and thousands of records, and aid us as attorneys in recreating and piecing together years worth of events that unfolded on a project that went wrong. It's also a very adversarial process, and despite the best of intentions by counsel to keep things focused on the project at issue, you and your people could end up being personally attacked through the process, which is just never something fun to go through. So while construction claims and litigation are in some cases inevitable on even the best of projects, there are some best practices that you can implement to help minimize that risk. And we're going to look at a few of those today. So first, I wanted to look at some things you can do before construction even starts. So the best way to really avoid or minimize the risk of litigation is to do your due diligence before a project gets started. Really know what you're getting yourself into. And there are a lot of ways you can do this, but I thought I'd talk about three big ones today. First is researching and gathering information to vet your potential project partners. Tamir mentioned this briefly, but know who you're dealing with, know the companies that you're contracting with, and make sure that it's a risk you want to take on. Second, reviewing and understanding the contract itself. And third, taking time to thoughtfully plan out the construction process to the best of your ability before you actually sign the contract and dive in. So first, we'll talk about knowing your contracting partners. One of the easiest and most effective ways to avoid or minimize risk of litigation is it's really practical and common sense to simply do some investigation and know who you're dealing with on the front end. This applies at all levels. As a contractor, make sure you understand the owner and their goals. Look into their reputation and relationships with other contractors. Look into their design partners, who they've worked with in the past, who they're working with on this project. Is the designer out of state? Do they have local representation that would allow them to be on site on a regular basis throughout construction to troubleshoot issues? This is one that comes up a lot. If you're contracting with an owner who's utilizing a designer that is out of state, they don't always have the on-site representation, and they're not always fully in tune with the issues that are going on the ground and seeing it unfold. And that can become a real problem. And we've seen it become a real problem in certain cases. So ask those questions, understand those issues before you decide if it's something you want to jump into. As an owner or an upstream contractor, look past the bids you're receiving. The lowest bid isn't always the best bid. Look into other projects that the contractor or subcontractor you're looking to deal with has done in the area. Talk to others about their experience, how things have played out on other jobs. If it's possible to do this, look into how many other projects they have going on at the same time and their resources. As Tamir mentioned during his talk about contract provisions, this is a time where labor forces are in demand, and people are trying to get as much work as possible. Make sure that what they're signing on for is something they can really do. While they may have the risk of that, you as the owner, you want your project completed in time and under budget. Make sure that it's realistic for them to be able to do that. Also look into litigation history if you can. There are definitely parties that we've seen on all sides who may have a reputation as being either overly litigious or, on the other hand, can be really litigation and risk averse. Try to vet that before you get started and make sure that their philosophy on how to deal with claims, matches up with yours as best you can. While some of this may seem like common sense, you'd be shocked how many cases we see where this important and relatively easy step is somewhat taken for granted. Many cases we see involve projects where the parties have never worked together before and their business models simply don't mesh. Communications break down during construction, issues hit the fan, and then everyone ends up losing as claims escalate into litigation. make sure if you're testing out a new construction partner, you know as much as you can before you get into it, so you can anticipate and mitigate those issues if and when they start to pop up. Other cases we have dealt with, involve repeat litigation between the same players on different jobs. Some parties just simply don't get along, and zebras don't always change their stripes. Really think about that. Sometimes there are project level personality differences that may cause an issue on one job that you don't see on others, but sometimes the issue is bigger than that. So think it through if you're going back into a situation with a party that you've previously dealt with and ended up in litigation with. Think through that risk before you decide if it's worth the potential reward. So again, just knowing who you're dealing with, ensuring their goals and philosophy of working through problems and proceeding on the construction job as they arise really line up with yours, and you can avoid and minimize the risk of litigation in so many situations. So another way, and Tamir talked a lot more about this, but a big way that you can minimize the risk and potential exposure you may face if a claim or litigation becomes inevitable is to really read, review, and understand your contract. If you poll arbitrators and judges about their feelings on what is important in construction cases, they would likely tell you that the single most important piece of evidence that they look at is the contract. So make sure that it says what you think that it says, and make sure that you know what it says. Build time in to read and review the contract and negotiate the terms when you can to make sure that those terms fit your company's risk tolerance and also the realities of the project and your business structure. I've noted on here just a handful of provisions that can be more important to look at, as these provisions typically become the center of what we as attorneys end up looking at and fighting over in the event litigation occurs. And these include your notice provisions, change provisions, payment provisions, damages limitations like no damages for delay clauses, limitations or waivers of consequential damages, liquidated damages provisions and caps, and in some, damage caps that limit exposure based on availability of insurance. And then also your dispute resolution provisions. Know what the risk is if you do end up having a claim that escalates into litigation and what that process looks like. In some contracts, there are really onerous dispute resolution processes that can be cumbersome and expensive before you can even present your claim and try to get resolution. On the other hand, you can be thoughtful in crafting a dispute resolution clause that builds steps in before you get to full-blown litigation, which will provide you the best opportunity of trying to really get the case resolved before you end up devoting time and resources and everyone digs in once a lawsuit has been filed. And don't just make sure that the person signing the contract understands it. Get the buy-in and involvement of your key representatives before the project starts as well. That's your project manager, even your superintendents. Project managers are the ones who are going to be living the consequences of the contract on a day-to-day basis during construction. And your superintendents could provide very valuable insight into how what the words might say in the contract look good, but don't really work in the field. You'd be shocked how many project managers that we work with once litigation starts or claims have escalated that either haven't read or don't understand some of these really key provisions in the project contract. Make sure that you don't find yourself in that situation and your people don't find themselves in that situation. It's also really easy for the people on the ground to get sucked in on the project to thinking it's okay to let certain things slide, to not follow up in writing. And the importance of the deadlines and contract requirements to provide certain things in writing to certain people can become really big sticking points in litigation. So make sure the people on the job understand their importance and what's being required. So if the first time the importance of a particular provision comes up is during your project manager's deposition in the middle of the lawsuit, that's a real problem. And it happens a lot more often than you would think. So the next and probably most critical way to avoid ending up in litigation is to take your time and review the site plans and specifications to make sure you're planning for a successful project. There can often be a lot of pressure to get this process done quickly, to get your bid in before you have time to really evaluate everything, or to sign your contract before you've had a chance to review or even received everything. push back, give yourself the time you need, and know when to walk if you're not satisfied with your ability to really investigate a job. While there are always unforeseen issues that come up on a job, taking the time to investigate those can avoid some of the biggest problems we see, and to have to wade through once a matter's in litigation, including scope gaps, bid busts, and schedule delays. I'm sorry, everyone, the joys of working from home. Screaming kids in the background. So the next, another place where a lot of the issues can actually be avoided or mitigated, I think I clicked through too many slides. The next place that you can really avoid and mitigate issues is during the construction process itself. So once a job gets started, simply speaking up, bringing the issues to the attention of the rest of the project team at a time when something can really be done about it can resolve the issue. If you wait too long, then the risk is too high for everyone involved. So speaking up early and then following up and talking about it often can really help to mitigate and avoid potential claims and litigation from escalating. Sometimes it's unavoidable, and that becomes apparent during a job as well. And in those situations, you should reach out as soon as possible to counsel, bring experts on board to help you get through the job and to minimize that risk as best you can, and make sure that you're documenting as you go in the event that you ultimately have to present what happened on the job to an arbitrator or a judge or a jury. In my experience, waiting until the end of a job and hoping issues will resolve themselves once everything gets done is generally a really good way to end up in litigation. And trying to piece together a messy puzzle of where things went wrong and why. So getting counsel on board, getting experts on board during construction to help you document things can help significantly. And a couple ways you can do that. Every project is different, and it really is going to be a case-by-case analysis of the best approach to minimize the risk of litigation in each circumstance. But there are two pretty universal ways you can and should proceed during construction to minimize that and to set yourself up for the greatest chance of success if you find yourself in litigation. The first is communication. Your contract likely contains a variety of notice provisions. Make sure that you know what they are and you're complying with them. Failure to provide notice when it's required and in the manner required can be a huge problem and sometimes fatal to your claim. Don't make that mistake. Make sure that you're notifying who you need to be notifying if there's an issue that comes up. In addition, the formal notice is required by the contract. Make sure you're bringing issues up in writing as early and often as possible. If nothing gets resolved or the issue is ignored, keep pressing it. Make sure you're documenting things in writing as well. Next to the contract, the second most important and credible piece of evidence if you find yourself in litigation is going to be contemporaneous written documentation or communications. Make sure you follow up on-site meetings and discussions in writing. Get your position out there and make sure that it's not misinterpreted or misrepresented. A verbal agreement or understanding is often only as good as the paper it's written on, so don't rely on that. Make sure you're also checking the meeting minutes if you're not the party responsible for providing and circulating them. I have seen multiple situations where meeting minutes may misstate what was actually discussed or agreed on the job. The best time to correct that is right after the meeting happens. Make sure that you're reviewing those when they come in and that they say everything that was addressed and accurately document your position on any issues that may have come up. Don't be the one who realizes for the first time during a deposition that it doesn't say what you thought it said. Review those and keep up with them during the job. Overall, litigation is costly. No one wants to deal with it. So do the work on the front end, keep up with the paperwork and documentation, and you'll have a better chance of navigating issues without finding yourself in fully blown court battles with your project team. Next up on the agenda this morning is Christian Hendrickson. Christian is a member at Sherman & Howard with broad litigation practice, including over 20 years of experience representing clients on all sides of construction disputes. In addition to his litigation work, Christian is also actively involved in legislative and policy efforts that impact the construction industry at both the state and local level. So he'll talk to you guys about some of the updates there. Thanks.
Thanks, Mary Sue. And I can vouch that one of the Murphy's laws that we've learned in the last year is that when you present on Zoom or any of these platforms, that children and dogs seem to find out when your time to present is, and that's when they get the most active. So I snuck down to the office because I have kids that do the same thing. Good morning, everyone. It's good to virtually be with you again. As Tamir said, we're obviously very sad to not be able to see you in person and meet old friends and make new ones. But hopefully we'll be doing that next year. Here today to talk a little bit about legislation affecting the construction industry. Usually we call this an update. I'm calling it predictions this year because usually the legislative session is off and running by the time we hold this seminar. This year, as you may know, the legislature met in January to take care of constitutional requirements, and then they put off the start of legislation and the session to this week. So we're just now hearing about what the session is going to be like, what it's going to entail. So we don't have, official bills really to run through. We can only talk about what we're hearing, and that's what I'm here to do today. So I think that where we should start is before the pandemic. It's obviously a new world. So where were we? We had national gridlock. There wasn't really a lot of sort of sole party agenda going anywhere nationally. We have a heavily uneven state government here in Colorado. The best way to explain it is there are more Democrats in the House of Representatives than there are in all of Republicans in all of the legislature. And you couple that with a strong Democratic governor and a Supreme Court that was largely appointed by Democrats, and you can see that one party has control over the situation. And again, nothing I'm saying today is taking a political position. I'm just pointing out the realities of political party control. We also were starting to see growing activism by local governments. Here in Colorado, before the pandemic, there was a push beginning on green building standards and being more environmentally conscious. And there was specifically a construction defect bill that was a pro-plaintiff bill. They called it a consumer protection bill that would lengthen the statute of repose. And the intent of it was to extend the amount of time that people could discover problems and then file lawsuits against builders and design professionals for those problems. That bill was being hotly contested. It was unclear whether it was going to pass. And then the pandemic hit. The legislature effectively shut down for the year other than to focus on emergency measures. And then they're pushing into, obviously, this new term. So during the pandemic, we didn't see quite as much sort of traditional legislation on these issues. We saw largely COVID-19 based legislation. In terms of our industry, we saw a lot of measures to address worksite issues, worker safety, and construction standards and how projects were being built. One issue that we noted, and that it will be interesting to see how it plays out, was the idea of distancing at a work site, less people on site, trades distancing and coming at different times. And the concern, of course, we have is that some of the best construction and some of the best problem solving happens by, as Mary Sue just said, collaboration and communication. So when you're taking people that are generally used to working together, standing together, looking at issues, looking at problems and solving them, and telling them that they can't be on site at the same time, obviously there's concerns that some quality may have been compromised through those types of regulations. So we're obviously going to be keeping an eye on that. And then obviously COVID relief was at the forefront. And so that's where we were sort of during the height of the pandemic. And as you've heard, they're back in session. We just got State of the State and leadership talks this week in the state legislature. And as you're seeing, COVID relief continues to be the number one issue. There's a focus on jobs, economic stimulus, helping businesses. A lot of the focus is obviously on businesses that couldn't be active in the last 12 months. And then housing is really key. I do help some housing clients. Right now, we're hearing of at least 12 housing bills that address all sorts of things in terms of building and rental agreements and all sorts of issues on that front. But those are the type of issues that the Democrats who are running the agenda are really focused on right now. In terms of the construction industry, A lot of focus is going to be on OSHA, which you'll hear about, and other regulations about how businesses are going to open and how office settings are going to be permitted to reopen and have more people there. So as we look into the proverbial crystal ball, again, a lot of this is guesswork, but we're starting to get some hints from those in leadership. The one thing that is a bipartisan agreement is that infrastructure is key. There's big federal money towards it. And while the state is out of money, they're trying to find even more money to put into infrastructure. But we've already heard this week that the Democrats and Republicans are not in agreement over how that money is going to be spent. But importantly, if your business involves infrastructure, particularly roads, highways, and bridges, certainly keep an eye out and be in touch with your legislators, because you can have an impact on how that money is spent and likely how it's going to impact your business. As I mentioned, there's still a key focus on worker rights, really in two aspects. The first is safety. There's going to be OSHA, there's going to be site standards, and that's just going to continue to be an issue both from a state perspective and obviously nationally with the new leadership in place and the new partisan control. And then compensation and benefits. They are focused on ensuring that workers are going to have appropriate benefits, appropriate compensation, and it's going to be more expensive to employ people. There's talk of a prevailing wage act in 2022, so keep an eye out for that. They're going to start to actually govern what people are paid. And then on the national level, there's the PRO Act, Protecting the Right to Organize. This is a strong pro-labor, pro-union bill. ABC, an industry group we're proud members of, they're taking the lead on opposing this. They're very against it. Actually, part of this bill is to address a case result that our partner Patrick Scully obtained in a case on a union issue. If you have union or labor issues, certainly come to us. We can put you in touch with him. And the other potential bill is a 5% maximum on private construction retention. So if it's a private project, they're looking at putting a 5% max on retention. But as I've said, we've got the same legislature in Colorado, the same leadership. The recent election only solidified the Democratic control. And obviously nationally, we've got now a one-party controlled situation. So I do think we should be looking out for environmental and climate affecting legislation in construction. Green building standards are going to be key. There's talk of electrification measures that basically say they want all power to be electric instead of natural gas. The thought being that you can fuel electric by solar, wind, and other alternative sources. There's talk of Energy Star benchmarking, which means if you build something, it has to meet a certain threshold. And if you go higher, you can get tax incentives. If you go lower, you can get penalties. There are talks of carbon tax. And we've heard about some of these measures from AGC, another great industry group we're affiliated with. And then net zero energy rules, where they're looking at making sure buildings are designed so as to take in as much and enough energy as needed to actually fuel the building. Look at other local measures. You may remember the Denver Green Roof Initiative. That was really scary. And then it got amended to make it more workable. And also, it's not just even the local governments, but they're getting support from the voters. This last election, the Denver voters said that they, from the confines of the city and county of Denver, are going to, impact and resolve climate change. So keep that in mind. And then as we were seeing before the pandemic, there were efforts to slow and even stop development. Currently, not a high priority, but Colorado obviously came out of this strong and is continuing to come out of this strong, and people are continuing to move here and businesses are moving here. So I could see the development impacting local measures come back to the fore. So keep an eye out for those. As I said, the priorities right now are COVID-19 and COVID-19. I would say next, infrastructure, keep an eye out on that. But given the state and national control by one party, just be realistic. It's going to be more expensive because you're going to have to build to higher ecological and environmental standards, and you're going to have to spend more on your workforce. So just be realistic as you're doing your business planning. Get an understanding of what the issues are and get involved and be involved in discussions with your legislators and your local governments to educate them on the issues, and that may help the policies that come out of some of this legislation. So thank you for your time. I'm going to turn it back to Tamir, who I understand is going to lead questions at this point.
Do you predict unions strengthening in Colorado and becoming required on public projects? Did you guys hear me? Somebody said I was on mute. No? Can you hear me now? Okay. Sorry about that. Christian,
Yes.
First question to you. There we go. I don't know what happened there. I apologize. Okay. With the state's focus on worker rights, compensation, and benefits, do you predict unions strengthening in Colorado and becoming required on public projects?
So long as this is noted as simply a prediction. Yes, I mean, I think with the strong Democratic control in Colorado, that unions are going to be encouraged. And obviously at the national level, that's being backed up as well. I think this PRO Act is going to be a big fight because, you know, it's going to be kind of an all-in issue for both sides. And so I don't know that they'll be required, but I certainly could see them being encouraged. And I think they're, you know, the point of that PRO Act is to make it easier for unions to gain a foothold and to kind of maintain control. So that's definitely sort of the direction that the leadership at the state and national level want to go. So, you know, again, if that's a concern to you, I certainly encourage you to get involved with your industry groups and try to get communications with your local leaders.
Thank you, Christian. As Christian mentioned, we have Patrick Scully and our labor team are fantastic. So if you need assistance on those issues, they're the people to talk to. In addition, next question is for you, Stephen. With the states, first, the question is,
I'm here.
Somebody's asking for the citation of the trust fund statute. So if you can provide the citation to the trust fund statute. But then the more direct question is, what steps can owners take, if any, to ensure their general contractors are properly paying project funds downstream?
The first question, the trust fund statute is 3822-127. There is a similar statute, 3826, I don't remember the number, I think it's 123, for public works claims. That is, you can't file mechanics liens on public property, and so there are bonds, but it still applies even if there are no mechanics liens. Owners can get payment applications that require that the contractor list each of its subcontractors and then verify that each of them has been paid and require lien releases from each of the subs. That way, the owner can send out occasional notes to verify that people have been paid. There's an overt representation in the payment application, and that way they at least get a representation. It doesn't stop the contractors from lying, but it certainly serves as one check. An equally or sometimes more effective mechanism is for the owner to take out of the contractor's hands the responsibility for paying subcontractors. Many lenders require this, so when a payment application comes in from a contractor, the contractor doesn't get money to pay the subs. The contractor lists the subs and then sends the payments directly from the lender. That does not cover those people who happen to turn in payment applications late. So if a contractor gets a payment application for $1 million, pays $800,000 to subs and keeps $200,000, there might be $200,000 worth of work that just hasn't been billed. But those are the most effective ways for an owner to protect itself.
Thank you. Mary Sue, this question's for you. You mentioned the documenting and making sure meeting minutes are accurate. How do you do that, and what about daily reports?
So I think that I would send the same caution for daily reports that I did for meeting minutes. So any sort of contemporaneous written documentation of discussions or conditions on site, I think just reviewing them as they come in. You likely are receiving copies of them, or your project managers are receiving copies of them as they are prepared, or they're being uploaded to some sort of a shared site where you have access to them. Maybe once a week, making sure that you check what they say. If there are photographs or something that differ from what's in some of the daily reports or meeting minutes, request that they be attached. If there's statements that are attributed to you or your team that are not accurate, or if there are certain issues that were brought up that you see missing from those minutes, just make sure you're reviewing those at least once a week during the project, and that they do in fact accurately represent what's going on the project. It's just a really difficult thing to come back and deal with it later if they don't.
One last question for Christian. You mentioned the 5% retention bill for private projects. What's the status of that bill, and how far do you think that's going?
So that bill has not been introduced. Obviously, they just got back this week. It's just been in discussion, but certainly something to keep an eye out for. Obviously, I think there will be pushback on it, and it will depend on kind of who's behind it. Like I said, I've worked on some housing bills and talked with some legislators and some leadership, and it really depends on what the leadership is behind. The good news is, as I mentioned, they're so focused right now on issues, really critical, like housing and those sorts of issues. So I think that we should keep an eye on it, and it's certainly something we will do. And if we find it, we'll throw out an advisory to let people know. But I have to be pragmatic and realistic and say that even if we don't like it, there's a pretty good chance it could pass if it gets all the way to the floor, because, of course, of the makeup of the leadership.
Well, let me thank this panel very much for speaking to everybody today. We are about to take a 10-minute break to give everybody a little bit of to do what they need to do. We are posting a poll question during that break. Feel free, if you can, please take a look and answer that question to our benefit. We will be starting back up sharply at 9:07. Thank you so much, everybody. See you in a few minutes. Welcome back, everybody. Thank you so much for coming with us, staying with us. Next up is Pat Miller, our OSHA Specialist Supreme, to talk about latest under OSHA.
Thank you, Tamir. Before I get started, I just want to echo what other speakers have said here this morning about how much we really miss doing these in person. I was sitting here during the break, reminiscing on all the years past where during the break we get to walk around, shake hands, see people, and like everyone has said, hopefully next year. So a lot of activity going on with OSHA under the new administration. We'll start with some new faces. So President Biden has nominated Marty Walsh to be the Secretary of Labor. Obviously, OSHA falls under the Department of Labor. Little background on him. Mr. Walsh is the mayor of Boston, comes from a very union-friendly background, has always been known for very tough pro-labor stances. And I think in large part he was selected because of that background. And while most of the impact I think his nomination will have will be with respect to organized labor, we do expect to see some more aggressive moves from him on the OSHA front as well. There had been talk that Bernie Sanders was going to be the Secretary of Labor. In fact, he openly advocated for that position with then President-elect Biden. But what ended up happening is when the Democrats won the Georgia runoffs, they didn't want to risk losing the Senate majority by having a senator go over into the cabinet. So in his announcement of Marty Walsh, President Biden did actually say that Sanders wanted the job. He was seriously considering that, and that he expects Senator Sanders to work closely with Marty Walsh. So expect Senator Sanders' hand to be on some of these issues as well. The Deputy Secretary of Labor, who is a number 2 spot, it's a Senate confirmed position, as is the Secretary of Labor. And just to note, Marty Walsh has already passed his committee hurdle, so he got through committee, and I expect he will be voted in by the Senate as well. So the Deputy Secretary of Labor, Ms. Liu, comes to us from California. She actually ran the Alocation program there, which is everybody, especially if you have operations in California, you know how different from the feds they can be, and how much more aggressive they can be. And that might be important here, her nomination, with respect to some of the COVID-19 matters that I'll be discussing here in a second. One more new face to talk about at OSHA briefly, and that is Jim Frederick. Now, this is not a Senate appointed position. So what he is right now, until we get a nominated and confirmed head of OSHA, which we don't even have a nomination yet, Mr. Frederick will be running the agency on a temporary basis. He was with the Steelworkers Union for a number of years, I believe 25 years, and we expect him to be very aggressive when it comes to enforcement until such time as we get a full-time head of OSHA. Okay, so I want to talk a little bit about the emergency executive order, or just executive order, I should say, related to COVID that President Biden signed later last month. So what this, among other things, the main thing that this executive order did for OSHA purposes is it requires OSHA to look at enacting what we call an emergency temporary standard. The normal way to promulgate an OSHA standard is to go through what we call notice and comment rulemaking. OSHA publishes a standard, puts it out, gives interested parties, businesses, labor unions, lawyers a chance to comment on the proposed rules. OSHA reviews the comments and then decides what to do. That process can take years sometimes. So the Occupational Safety and Health Act has a provision for enacting emergency standards. So during the beginning of the pandemic, the AFL-CIO actually sued OSHA to require them to promulgate such a standard related to COVID, and they lost that legal challenge. But what Biden's executive order does, and it didn't go as far as a lot of people thought it would or wanted it to, it doesn't require OSHA to come up with an emergency standard, but it asks them to revisit that decision not to. You can see here that a number of states that operate their own safety and health plans have already enacted those measures. Some of them are very stringent. California, again, comes to mind, and some are a little more relaxed. So one of the issues that is going to come up in the emergency standard, and I think OSHA will actually promulgate one. They have until March 15th to do so. One of the issues that's going to come up, however, is it going to apply to construction? As you're all aware, there's a different set of standards for construction versus general industry. So it is possible that OSHA could say, we're only going to make this emergency standard applicable to general industry because we think that's where more of the transmission risks are. Don't know how that'll work, or if they'll issue two sets of standards, one for construction, one for general industry. As we're all aware, the precautionary measures you take in offices to help with COVID-19 are vastly different from those in the construction area. So we don't know. They could issue one standard for both that applies to both. We see that in other areas like HAZCOM. They'll put it in the general industry standards and then make it applicable to both. But we just don't know what it's going to entail yet. So in order for the standard to pass muster, though, OSHA has to show two things. One is that there's a grave danger to employees because of a new hazard that's out there. I doubt very seriously that any legal challenge to an emergency standard will be able to say that there's not a grave danger from the risk of COVID. However, the problem that the standard is probably going to have is the second prong of the test, and that is whether the standard is necessary to address that hazard. I think what the response from industry is going to be is that whatever OSHA comes up with, they're probably going to say, the challenge would say, it's not necessary to protect from this hazard because we're already doing all of the things that you, OSHA, are requiring us to do. Problem with that argument, obviously, is OSHA will say, well, not every state is mandating these things. Not every local government is mandating these things. We need a federal standard. So stay tuned on that. There will be a challenge to it no matter what happens. And these are the steps that need to be met to have the standard actually stayed. Now, a legal challenge just means you go to court in the circuit court, either where the employer is or in the DC circuit, and you argue that those two prongs aren't met, that there's no grave danger or that it's not necessary to have that standard. But to get a stay, which means that the standard isn't immediately enforceable, you have to show all of these four prongs. And there's a strong showing that you're likely to prevail, that without the stay, there's going to be irreparable harm, or that others will be substantially harmed as well. In other words, it can't just be affecting one business, and that it's in the public interest. I think it's going to, the irreparable harm portion is going to be interesting to see how employers argue that. For the industries that are still lucky enough to be in business, I don't know that any new temporary standards will cause them to now go under versus what has already been required through state and local mandates. So I think it's going to be an uphill climb on any challenges to the emergency standards. So as soon as that comes out, if it comes out, we'll be ready and we'll be providing updates as to what they are. I'm not going to go through the rest of what the executive order really talks about. One thing that it did require was for OSHA to issue revised guidelines for your COVID-19 programs. I've put them all here. I'm certainly not going to go through all of them, but I wanted everyone to have them. This is, again, it's not enforceable. This is just guidance that OSHA was directed to put out, and most of what they did we're already seeing with employers in terms of what they're doing with their COVID program. So nothing really earth-shattering there. Again, these are some of the other requirements of the executive order. I think the main one is Biden really wants OSHA to ramp up enforcement on COVID, and he wants certain industries to be, I don't want to say targeted, but let's say emphasized. And that's food production, grocery stores, things like that. We haven't seen that kind of emphasis for enforcement in construction just yet. A few other things to expect from OSHA under the Biden administration. Actually, during the campaign, President Biden pledged that he would double the number of OSHA compliance officers. I think that will happen. OSHA has a very small budget, and it doesn't to increase it, even to double it, wouldn't be a huge dent to the budget. So I think we're going to see an increased budget and more compliance officers, which obviously means more inspections and more citations. So we're kind of going back to the Obama years in terms of OSHA enforcement. Other things that we can expect: more significant enforcement cases. Those are cases that are worth more than $100,000. More press releases. This is something that OSHA under the Trump administration got rid of. That's kind of the name and shame game, where when a citation is issued, OSHA issues a press release. And more record-keeping enforcement. I would note, too, although it's not in the slide, at least locally, we're seeing a lot more enforcement when it comes to silica. So make sure you have your silica programs up and running. OSHA, especially here out of the Denver area office, is really emphasizing that these days. Retaliation is going to be a big issue. This is something that had really lied dormant under the Trump administration, but there are numerous statutes that OSHA investigates for retaliation purposes. I expect that part of OSHA to be definitely increased, and they might even start enforcing their own anti-retaliation standard that was promulgated a few years ago that actually makes it a violation of the OSH Act to retaliate against employees who report injuries or illnesses. And the result is actually a citation rather than litigation, which will be very interesting. So stay tuned. There's a lot on the horizon with respect to OSHA. And like I said, we'll be putting out updates frequently as these issues develop. So with that, I would like to turn it over to my partner, Beth Ann Lennon, who has encyclopedic knowledge of everything that is going on with employment law these days. Beth Ann, take it away.
Thank you so much, Pat, and welcome again, everybody. Thanks for joining us and giving us your time this morning. I asked the organizers to give me about 4 hours to speak with you because there's that much going on in labor and employment law. And they said no. They said I get 12 minutes. So we compromised, and I have put a lot of material in my slides. I did that intentionally for you guys so that you have something to refer to when we are done here, right? There is a lot that has been going on over the last year. So last time we spoke, for those of you who attended the seminar last year, was on February 28th, 2020. And you guys might have actually been the last big group of people I was with before the pandemic hit. And there on that day, on February 28th, I truly believed that I was telling you about what would be the focus of employment law here in Colorado, especially in the construction industry over the next year. And that was Comps Order number 36. As you may recall, this is the first time as of March 16th, 2020, that the construction industry was specifically covered by Colorado wage and hour laws in nearly 2 decades. So there was a lot for you guys to do, and hopefully you have done those things over the last year. However, even before that happened, on March 11th, 2020, the national public health emergency in Colorado was declared when COVID made its way here, and the attention of employment law and employers in the state had to shift pretty dramatically and pretty quickly. And this is why I wanted 4 hours with you, right? We had more than a dozen executive and public health orders come out here in Colorado that directly impacted operations for anybody who employed anybody here in the state of Colorado, and especially people in the construction industry. We had the legislature and the governor pass 2 new laws in quick succession that they made effective immediately, right? The Healthy Families and Workplaces Act and the Public Health Emergency Whistleblower Act. So unlike most laws where they get passed and then you have about a year to get your house in order, for some of these you had 1 day before they became effective. Similarly, the Colorado Department of Labor and Employment, which interprets existing laws, got real busy and started issuing guidance on what employers were expected to do with some laws that already were in play. That includes an update to Comps Order number 37 that became effective January 1st of this year, right? So that Comps Order we talked about last year that now applies to the construction industry, it's been updated a little bit, not huge changes, but again, if you're not in compliance with that, you're not in compliance with Colorado law. There's also been the Equal Pay for Equal Work Act, which was passed in 2019, but became effective January 1st, 2021. And throughout 2020, the Colorado Department of Labor and Employment started issuing tons of guidance regarding what we are expected to do with regard to that law, which is now effective as of January 1st of this year. And then, just because we weren't busy enough, the voters did pass Proposition 118, which provides for paid family and medical leave through an insurance program here in Colorado. So that's in addition to the Healthy Families and Workplaces Act, which provides for sick leave that all employers in Colorado have to pay. So again, I would love to spend hours talking with you guys about these things. They gave me 12 minutes, so we're going to cover 2 of these changes, the 2 you really have to have on your radar right now. And I have put a lot of materials in these slides, not because we're going to have time to talk through all of those materials, but rather so that you have something to refer to when you're coming back to this and saying, Beth told me there was something I needed to know about here. What is it that I need to do? So we're going to start with HIFWA, the Healthy Families and Workplaces Act. Now, this is paid sick leave for here in Colorado. It was passed effective July 15th, 2020, and it actually had 3 different provisions in it. But we're going to focus on the parts that became effective January 1st of 2021, because those are the ones that apply now. What's going on in 2020 is done. That stuff doesn't apply anymore, so we're in the reality of right now. So this says that employers in the state with more than 15 employees have to be providing regular paid sick leave for certain covered reasons, with a couple statutory minimums applying to that. So it applies to your temporary workers, it applies to your part-time workers, it applies to your full-time workers, it applies to your exempt workers, it applies to your non-exempt workers. They all get paid sick leave under this law. And for those of you who are sitting there saying, great, I have 10 employees, I don't have to pay attention to Beth for the next 3 minutes of her presentation. Unfortunately for all of you, this law will apply to, this portion of the law will apply to every single employer in the state, even if you just employ one person starting January 1st of 2022. So you should pay attention as well and use this opportunity to get your house in order. Okay, so what does this law require? What's the statutory minimums I just referenced? You need to provide 1 hour of paid sick leave for every 30 hours worked. Employees are entitled to accrue up to 48 hours per year. It has to be available to be used as soon as it's accrued, right? So you can't hold it back and make people accrue a certain amount before they can use it. Employees start accruing from the very first day they come in on the job. I'm going to repeat that one because a lot of people who have provided paid time off before have also required some sort of waiting period. So if you have a policy in place that says, I will give you some sort of paid time off, but you have to work here for 90 days, and then you have to accrue a certain amount before you can use it, that's not okay anymore. They start accruing from their first minute on the job. This paid sick leave rolls over at the end of the year. Up to 48 hours of it needs to be rolled over into the next year. When somebody uses that paid sick leave, it's going to be paid out at the same rate, and the employees have to be getting the same benefits they normally earn when working. So keep in mind, if you have somebody who's out on paid sick leave, they're still going to be covered by all of the benefits you provide them, including things like healthcare and accruing vacation. Another one that some people might have to change if they have an existing policy, it needs to be able to be used in an increment of 1 hour or smaller. And here's the thing, if you don't have anything in the policy referencing the appropriate increment, it's 6-minute increments. So don't adopt the billable hour like all of us attorneys have to. Write something in your policy that says the increment at which it will be used. So there are 5 covered reasons that people would be able to use paid sick leave under this law, and you have to have a policy that permits it to be used for at least these reasons, and you have to be explaining this to your employees. I'm not going to go through all of these. Again, they only gave me 12 minutes. What I'm going to highlight is there is both sick leave things that make sense as sick and safety things, right? If somebody is a victim of domestic abuse or sexual assault, or their family member is, and they need time off for things like relocating or obtaining legal services, that's covered under this quote unquote sick leave. So look carefully at these covered absences, make sure that your policies are addressing the permissible reasons that people can be using their leave. Now, the real kicker. So there's a separate provision in the Healthy Families and Workplaces Act that applies when we're in the middle of a public health emergency, which we all happen to be right now. So when a public health emergency is declared, including effective January 1st of this year, every single employer in the state, even if you only have one employee, needs to supplement the paid sick leave that they're providing their employees to make sure the employees may take up to 2 weeks of paid sick leave, up to 80 hours total, during the emergency. So you're like, okay, but we've already been doing that because the Families First Act was passed federally. I want to highlight that these are overlapping but not consistent requirements. And now that we are into this new year, you do have an obligation to provide paid sick leave under state law that is similar to, but just different enough to get you in trouble from that federal law. So keep an eye out if somebody needs to take leave for any reason that might be covered under the public health emergency. Again, a lot of information on this slide, and that's because these are the additional reasons that somebody might be able to take leave when there's a public health emergency. Make sure you know these and make sure your employees are aware of this, because one of the requirements is that they know what this policy covers. I wanted to highlight real quickly that you can have an existing paid time off policy that is sufficient to provide the HIFWA required benefits. You're not required to provide sick leave separately, but keep in mind it needs to actually comply with all of those statutory minimums that we talked about. And also keep in mind that if you combine vacation time and paid sick leave, you're going to have to pay that out on termination. So all of those employees who've worked for you for 90 days and then they quit, they will have accrued some amount of paid sick leave or paid time off that you're going to have to pay out. Again, this law has a lot of very complicated requirements, and I want to make sure you guys are aware of them. So look carefully at this slide, right? You need to make sure your employees are all aware of this law, that you're posting the appropriate posters, that you're keeping the appropriate records, and that you are structuring your policy, that you are not disciplining anybody for paid sick leave, absences, that you're addressing whether you're paying it out or not, and that you're aware that if you don't pay it out and somebody leaves but then comes back, that it has to be reinstated. I wanted a whole separate slide on this one because it's super important, and then we'll move on to the second thing I promised to talk to you guys about, and that's documentation. This law says that if somebody is absent for a public health emergency related reason, you cannot ask for any documentation in order to give them that paid sick leave. No documentation at all. And for non-public health emergency related absences, the absences of 4 or more consecutive workdays are the only instances in which you can request reasonable documentation. And that is very narrow and strict requirement here. So those of you who are used to asking for documentation, you can violate this law by just asking for that doctor's note that was totally okay before January 1st of this year. Okay. The Equal Pay for Equal Work Act. This one, again, hopefully is on some of your radar because it got passed in 2019. And it essentially says that you have to be paying all of your employees who are performing substantially similar work the same amount of money, right? Not that notable, you would think, but this law actually completely upends the way a discrimination claim is brought here in Colorado and is really unique even if you look across the nation. So the first unique aspect of this is that when we say that when you're paying somebody of one sex differently than the other, it's much broader than you would think, right? It's not just you have a male who's paid more than a female. It's that the gender plus, it's gender identity, any protected characteristic. They're going to compare people who are performing substantially similar work, and they will not be looking at job titles, right? Skill, effort, and responsibility. So if you have somebody who is being paid more, they're not just looking at that hourly rate, they're looking at vacation time, benefits, etc. And here, unlike under federal law, there is no get out of jail free card, right? It's I'm paying them something different because of something other than sex. This literally says you have to be able to point to one of these 6 reasons that are permissible reasons for paying somebody differently. Otherwise, you're violating the law. There's a whole list of things you can't do, including notably asking somebody what they were paid on a previous job or relying on information about what somebody has previously been paid when setting wage rates, right? And there's also new things you have to do. Most notably, there's posting requirements. And again, I'm giving you a lot of information in the slides so you can refer back to it. But I want you to understand that anything that's a promotional opportunity for anybody in your job, in your workforce, has to be posted. And when you post it, there are some very specific information that you have to include in that post, and that includes the rate of compensation being paid for that position. Lots of employers are not used to providing this information, and they're very uncomfortable with this idea that they have to be giving that information, right? Now, again, for your future reference, there are some exceptions to this rule, but they're very narrow exceptions, right? So if you can have a position that is not a promotion and you can hire it without posting it, you don't have to post. But if you do post, you have to include that information, including that compensation information, okay? So take a look at this when you're trying to figure out how you're going to fill those positions and make sure you're in compliance with this. Why? Because the cost of getting it wrong is huge. These are 2 super complicated laws. I would love to talk to you guys about them for hours, but unfortunately that's just not possible today because we want to be respectful of your time. So when you have questions, if you have questions, give us a call, because if you don't, you're going to be facing double damages, triple damages, fines of up to $10,000 for posting things wrong, and we want to help you avoid doing that. So I think I'm really close. Thank you guys very much for your time. Please do stick around for that question and answers. If you don't have questions, you're probably not paying attention because I have questions on these ones. But in the meantime, I would like to introduce my colleague, Jessica Errett, to present on, I'm sorry, I jumped too far, understanding indemnification rights and obligations. Jeff.
Good morning, everybody, and thank you all for being here. It's, again, a disappointment that we can't be here in person, but hopefully next year we'll all be together again. So I just wanted to very briefly cover kind of the ins and outs of indemnification provisions that are kind of in play, specifically in construction contracts. And so just starting off a real level set, what is indemnification? And this is kind of the most standard example that there can be, and I'll kind of be referring to it throughout the presentation. But indemnification is essentially allocating the risk within the construction site to kind of the entity who is most capable of being in charge of it. And so the most standard example is, let's say you have a pedestrian walking by the street next to a construction site. That person gets hit in the head with a hammer as the result of some sort of subcontractor negligence. The pedestrian doesn't know who hit them in the head with the hammer. They sue the owner, the general contractor, everybody that they can kind of locate on the site. The indemnification permits the general contractor to then seek indemnification from the person or the entity that was actually responsible for hitting that pedestrian on the head. And the reasons that we have indemnification, I think, it's relatively logical. Again, it's to make sure that that risk is being allocated, especially in the context of insurance, because we really want to make sure that insurance, that when you're going out to seek insurance for any sort of accidents that may happen, that you're only having to seek coverage for the things that you yourself can control, you yourself have responsibility for. And on the flip side, there was always there's been some instances in the past that Colorado has kind of tried to address where indemnification sometimes would go too far and would cover would permit a general contractor to seek indemnification for things that the general contractor was doing or the owner was responsible for. And so the goal of indemnification really is to seek coverage for those things that the specific person, the specific entity themselves can cover. All right, so what to think about when drafting indemnification provisions. And this is kind of gets back to the basics of contract law. You really want to make sure that you're being specific in your provisions. And with indemnification, it's actually, because there's not boilerplate, it's not kind of a standard provision that you put in there, you really do want to be paying attention to exactly what sort of things are being covered and making sure that you're understanding all of the provisions in there, because it really can be something that impacts you down the line. So first off, making sure that you're understanding whether or not your indemnification provisions are covering only third-party claims or they're also covering first-party claims. So just so that we make sure everybody's on the same page, a third-party claim is kind of what I was talking about earlier, where that pedestrian or some third party is injured or has some sort of issue as a result of the construction. They are suing somebody that's actually involved in the construction, the general contractor. That would be a third-party claim. That's kind of the standard sort of situation that indemnification covers. But there has been a little bit of a shift to include first-party claims within certain indemnification provisions. So that would be, a first-party claim would be, say, the general contractor has some sort of damage that's directly incurred by them, maybe the delay in construction or some other cost that's incurred as a result of that subcontractor's negligence. That would be a first-party claim, typically not considered an indemnification claim. And so if you want that to be included in the contract, you need to be specific in making sure that that's part of it. The other really important thing to make sure you're being specific about is the damages that are going to be covered. Again, typically indemnification provisions are going to include protections for things such as bodily injury or property damage, but that doesn't mean that you are necessarily have to be limited by those things. So if you want to increase the scope of what's included in the indemnification provision, you can. For example, if you want to do something related to damages caused from some sort of hazardous material issues. You also want to make sure that you're specific about who is being indemnified. It might seem like you can just put in the name of your company and that's going to cover you, but that might not necessarily cover any sort of claims that are asserted against your officers, your directors, any specific employees or agents. And so if you want those people to be covered, you need to make sure and specify that in the contract. And finally, making sure that you're specific about the notice requirements in terms of notifying the person, the indemnifying party, of any sort of claims. And this is especially important if you're the entity that's going to be in charge of providing the indemnification, because you want to make sure that if there's some sort of accident, that the notice is provided in as timely a manner as possible, and so that you understand it as quickly as possible. And that's really so that you can do the investigation that you need to do. That make sure that all of the witnesses are still there, and making sure that you're able to really respond to the claim as in real time. And so putting in a notice requirement, kind of the standard is kind of vague. The notice needs to be provided promptly or timely, which is fine, and that does provide protection. But if you want something a little bit more specific, you can include something like notice must be provided within a certain time frame, say 90 days, or as soon as possible. All right, and the other thing to really think about when you're drafting these contracts is thinking about the kind of the scope of the obligation and the length that you want it to apply. So in terms of scope, if you just put in there that it's company A is indemnifying company B, indemnification really only kicks in once money has actually been paid out. And so if you're a general contractor that's sued but it wasn't your fault, and you just have an indemnification without a corresponding duty to defend, you're going to be responsible for dealing with that claim all the way through either settlement or judgment or some other situation where you're paying out money. So if you want to kind of wash your hands of that earlier, it's really important to put a duty to defend in there. It's basically saying that the indemnifying party has to assume the defense of you as soon as the claim is made. And this is also really important for protecting the indemnifying party, because if you are going to ultimately, as a subcontractor, are ultimately going to have to pay out and any sort of money for a claim against your general contractor, you're going to want to be in control of if there's any sort of settlement, you're going to want to be in control of choosing who the attorney is and the amount of attorney's fees that are incurred, and you're going to want to be in control of how that defense is actually being done. And then second, and this is kind of a standard contractual clause, but it is really important, indemnification is one of the few provisions that you always want to make sure survives any sort of termination of the contract, because you don't want to end up getting into a fight about whether if the contract for some reason terminated, whether or not you're still covered by that indemnity. All right, and so then things to think about when you are, sorry, I just skipped one of my slides. And so one thing that's really important, especially in Colorado, is that you want to make sure that within construction, there's a specific law about indemnification that you need to be really aware of. And that basically says that you can't have an indemnification provision where the indemnifying party is indemnifying the negligence of the party that they're indemnifying. So in our situation that we talked about in the beginning, the subcontractor cannot be indemnifying the general contractor for some sort of negligence that the general contractor did. And that might seem obvious, but until this law was passed, that sort of provision was actually quite common, and it was leading to a lot of issues, especially on the insurance side for subcontractors. And so in Colorado, we have a statute that says that that's not permitted. And in fact, if you have an indemnification provision like that, it's actually considered to be void. And you can't get around it by adding in a choice of law clause, because it says that it applies to any construction property in the state of Colorado. And so you can't say, oh, well, I'll just get around it by saying this is under New York law. And so you want to make sure that your contracts are complying with that, and actually including some sort of a savings provision, so that even if for some reason some court interprets your language as being in violation of that statute, you can say, look, we want to comply with the statute. We want a court to interpret it as complying with the statute. And then another thing to kind of think about in that context is for a little bit, people thought, oh, I can get around by just saying that requiring the subcontractor to insure the general contractor for any sort of negligence. And courts have said that that's also not permissible. You can say that you can put a general contractor as an additional insured, but only for the negligence of that subcontractor. And in reality, insurance companies wouldn't let you do it the other way anyway. Okay. So thinking about if you are faced with some sort of an indemnification situation, things to think about, things to be on alert. Again, going back to that notice, you want to make sure if there's a claim that and you think that is covered by indemnification, that you're providing that notice as quickly as possible. Again, it's kind of similar to when you are dealing with an insurance company. You want to make sure you're notifying your insurance company as soon as possible. The same principles apply to any sort of indemnification. You also want to be thinking about if there are multiple parties at fault. And so if you are that general contractor in that example, and you think that there might be a couple subcontractors that might be responsible, making sure that you're notifying all of them. And on the flip side, if you're the subcontractor and you think there might be additional parties other than yourself that might have responsibility, including that general contractor, making sure that you know that right away and you're documenting that so that you can properly push back when you need to. And then again, thinking about whether or not that duty to defend has been triggered, you want to make sure that as quickly as possible you're getting the right attorneys. Whether it's the subcontractor making sure that they're getting their attorneys in there, or the general contractor getting their attorneys in there, and making sure that you're really understanding if it constitutes a covered loss under the provision. So again, if you have an indemnification provision that only covers, say, physical injury, and there's some sort of property damage, both sides need to be making sure that they're aware of the ins and outs of that coverage. And then timing is also a really important thing when you're facing some sort of an indemnification situation. So you want to make sure that you're understanding exactly when those obligations are kicking in. And again, as I kind of alluded to earlier, those obligations can kick in differently for the different types of obligations. So your duty to defend is going to kick in earlier than your duty to indemnify. So in terms of timing and in terms of asserting those rights, you want to make sure that you're asserting the proper one at the proper time. Because if you're waiting a while until you actually have to pay out on the fine or the claim or something like that, you might have missed the window for asserting your right to have the defense costs covered. And similarly, also understanding exactly when those claims accrue. And so there was a question under Colorado law as to whether or not the claim accrued as soon as there was notice of the claim or as soon as the payment actually was paid out. And in Colorado, the kind of result that everybody has reached is that the obligation to actually, the claim for indemnification doesn't actually accrue until someone has actually made the payment. And so in terms of asserting your rights or saying that someone has breached an indemnification agreement when there is no duty to defend, you can't actually assert that there's been some sort of breach until you yourself have paid out on that claim. Right. And very briefly, I just want to cover kind of how indemnification corresponds with workers' compensation because that can be a little confusing sometimes. So kind of the typical situation is you have, again, like we said at the beginning, subcontractor B one of their employees maybe is injured on the job, and that employee seeks workers' compensation through their employer through workers' compensation insurance. And typically then is that subcontractor employee is like, great, I'm done with that. I'm immune from any sort of other obligations that I might have to this employee. I've paid out the workers' comp. Well, that employee goes on and sues the general contractor or the owner of the construction site. And then through indemnification, those parties end up coming back to the subcontractor and saying, look, you have to indemnify me for these losses that your employee incurred. And so sometimes people think, oh, well, I'm immune. I shouldn't have to worry about it. And if there was no indemnification provision in there, you would be right. Under the common law, you're not obligated to provide any sort of common law indemnity to those general contractors or owners. But if you have an indemnification provision, courts have said that that contractual obligation kind of trumps the general immunity that comes through workers' compensation. And so you could be on the hook both for that workers' compensation insurance and any sort of indemnification that might flow through your contract. And so that's just another thing to think about when you're talking, and again, being specific in the contract to make sure everything is clear. So if, the parties decide that they don't want, a subcontractor to be liable outside of workers' compensation, they want to make sure that they're immune, you can put that into the contract. Otherwise, it's going to be assumed that there is no immunity through that indemnification provision. All right, and I think I covered everything. I'm sure that was super fast. But right now I'd like to turn it over to my colleague, Jay Sturhan, who's going to talk about insurance.
All right. Hello, everyone. Thank you. My name is Jay Sturhan. I want to thank you for staying with us through this proceeding and this presentation. I'm going to get you out of here on time, but we do have a number of things to go through as it relates to insurance. And so I've broken my talk out into 3 separate parts. First, I just want to talk about some of the trends that we are seeing in the insurance market in general. Second, I want to check back in on COVID-19 coverage, because if you've been following the press as it relates to this issue, you know it's a hot button topic both for insureds and insurers. And then finally, I'll talk about 2 cases that came out this year. Neither are Colorado cases, but they both tell us a little bit about what we can expect and some strategic decisions that need to get made when you are fighting a coverage battle. So first, let's talk about trends. And no surprise for anyone who has been out in the market trying to either renew your insurance program or come up with new coverage for a project, and that is that the cost of insurance has continued to increase. On the slide here, you'll see some of the predictions that we were able to gather from some of the brokers that had published them out there. And you'll see the 2 big trends. One is just a general increase across the board for almost all of the coverages that would be important to the construction world. And then second, you see a rather dramatic increase in excess coverage. And we'll talk about some of the reasons why in the next slide. You'll also see that there are specific parts of the industry that seem to be getting hit harder than others, and that would be those dealing with residential construction and habitation, and those dealing with infrastructure claims. And the residential, we think, is because, again, the construction defect issues, and for the infrastructure, just the general complexity of those kinds of projects make them sometimes more difficult to insure. Schedule issues inevitably arise, and so you're going to see some increases in coverage there. If there is some good news in this trend, it's that despite the higher premiums, most insureds are still able to get the policy limits that would be required by their contracts and that would be required because of the type of project that they're working on. And while self-insured retentions and deductibles are certainly, there's pressure on them, depending on your project and depending on your risk profile, you still may be able to get those at limits and at amounts that make sense for you. And then the other thing we're seeing is that insureds on renewals certainly want a more detailed analysis of the claims history. They're going to want more information from you, not only about your claims, but also about your risk management processes. So let's then talk about the whys of this. And so the first thing we'll say is that this is not new. It's a general continuation of a trend that began a number of years ago. And unfortunately, we don't see an end to it in the near term, and we'll talk about why. One of the bigger reasons that we think is that claims have gone up, and we're talking both about the value of claims as well as the number of claims. And interestingly, the amount of time it takes to resolve a claim has also tended to trend upward over the last year or so. Various reasons for that, but if claims get larger, if they get more complex, and if they take longer to resolve, then of course insurance companies are going to react. And one of the ways they do that is through higher premiums. The third thing that we would see in terms of causes is, while you can't draw a direct line from COVID-19 to increases of premiums because this trend began before the COVID issues arose, it certainly doesn't help. COVID causes uncertainty. It causes impacts on schedule, and it can cause impacts on your workforce. And one thing insurers don't like is uncertainty, and COVID is certainly something that contributes to uncertainty. Other issues that have arisen, everything from increases in lumber costs, cyber risks, people continue to talk about. The coverage related to cyber risk remains very unsettled, both in the market and with how courts are dealing with it. Weather issues, as anyone who is in Texas can attest to, continue to dominate both the news and have major impacts on projects, whether it's storms or fires. And then there's just general economic uncertainty. I think all of those things combined suggest that we're probably going to be facing increased premiums, potentially pressure on limits, and increases on SIRs, self-insured retentions, and deductibles as well. So what do we do about it? Well, the first thing we would say is increased emphasis on the renewal process. That means starting the process sooner, being more deliberate about the kinds of information you share with your insurers, including everything from an explanation of prior claims to a kind of fulsome description of what you are doing to mitigate risk on your projects, both through project management, but also, more importantly, probably through your contracts, something that the insurers can really sink their teeth into and get a handle on how you're managing your risk. And when we talk about risk management advocacy, what we're really talking about is touting your successes. We have seen that this matters to insurance companies. If they have a reason to believe that you're going to be able to manage the risk better than others in the market, they're more likely to extend to you coverage on terms that are favorable. The other thing we'd say is if you're considering switching carriers in your insurance program, just recognize it's probably going to be a somewhat more difficult exercise than it otherwise might be, just because these are uncertain times, as we've heard again and again. And then we say this every year, but you really do need to engage good brokers. And by good brokers, we mean not only people who have exposure into the insurance markets, but those individuals who actually understand construction and understand your business, how you conduct your work. That's really going to be critical coming up this year. And then the final thing we'll say is that as your insurance changes, you're going to need to consider the impact that that would have on contracts. Most of your contracts are going to require certain kinds of coverages. They're going to require coverage not only of a particular type, but at a particular limit. So you need to be thinking about, one, am I compliant? Or two, is my subcontractor or others doing work for me compliant with their contractual obligations? And then finally, what can I do in my contracts to help pass along some of these costs that I'm having to incur for these insurance risks? So not great news on the market and the trends, but things that we can do. So let's talk a little bit about the COVID-19 coverage. If you've seen any coverage about this in the press, you know it was a hot topic early in the pandemic, because the idea was that commercial property policies could potentially pay for some of these risks and losses that arose from either outbreaks on site or governmental shutdowns. And there are a number of arguments that were made. What the courts were focusing on is that for a commercial property policy, or even a builder's risk policy, which is just a type of commercial property policy, is there direct physical loss? Or does your policy have a virus exclusion? And that's where the courts have really been focusing their attention to say, how can a virus, which is in fact a physical object, it's microscopic and small, does it actually cause physical loss of use? And that's where the battles have been waged here. So let's look at the actual scorecard. So what do we see here? In Colorado, we've tracked 5 suits that are currently pending. I would expect more to be filed. Those are, no surprise, kind of public-facing insureds, those who were primarily affected by the government shutdown. I mean, everyone was affected by the government shutdowns, but these were people and businesses that actually had to stop work for a period of time and limit the number of people that could be on site. And the news is, I have to say, trending in favor of the insurers at this point. And we've seen kind of across the country, and the data is certainly a little bit suspect, but only 4 circumstances where a court has affirmatively said, hey, look, We actually think there's coverage under these policies. And if you look at the statistics on this slide here, you'll see only 1.5% of all COVID claims have paid. 82% have been denied, and only 1% of those have resulted in a lawsuit. So the question becomes, should you make a claim? At this point, we're probably getting to the end of the period in which you could even make a claim, but our general advice was always, yes, make a claim. If it gets denied, which is almost certain, then you have a decision point to make, but you do have some time in which to make that decision. If you miss the deadline for filing your claim, then there's nothing you can do. So let's close this out by talking about two opinions that came down more recently, and less about the opinion in this first case and more about the strategic decision that was made. This first case, Cincinnati Insurance Company versus Charlotte Paint, that came out of the Federal District Court in South Carolina. It was a case that involved work by a subcontractor, and whether or not the scope of that contractor's work involved, this contractor was putting in windows, whether it involved also working on that part of the project that had the membrane on the project next to where the windows were being installed. The installer slashed that membrane in the installation of its work, and the court was deciding what is the scope of that particular part of work that the insured was working on. There were two cases pending. You have the construction defect case and then a separate coverage action, the litigation that was related to coverage. The lawyers in that case made the strategic decision to stay the coverage action, to stay the defect action to proceed with the coverage action. And that came back to have impacts when the court made factual findings about the construction work itself in reaching the coverage decision. And so that raises a really interesting question for us and for you that you will be facing sometimes when you have a defect action going on at the same time as your defect action, coverage action. Which do you stay? And we always tend to advise clients to go forward with the defect action if they can, so you don't get bad decisions made by a court on coverage. And then the second case that I want to talk about is just that a decision from the Ninth Circuit, which covers kind of Western U.S., California, Oregon, Washington, et cetera, basically said, hey, excess insurer, if the underlying insurer pays a claim saying that it's covered, you cannot challenge that underlying insurer's decision on coverage. So that's a good result for insureds who are facing claims that involve excess insurers. It hadn't been decided before, and now it seems like that's the trend. So that's it for a discussion of insurance. I want to bring Tamir back in, and if anyone has any questions for Beth Ann, Pat, Jessica, or myself, we'd certainly love to try to answer them. But thanks for hanging in with us.
Unmute again. There we go. Everybody, welcome back. Thanks so much for staying with us. We do have about 5 minutes for questions. Not surprisingly, Beth Ann's teaser on the 8 million employment changes has led to numerous questions. So let me start with a few of those to you, Beth Ann. We won't be able to get to all of them. One is the 48 hours per year of sick leave in addition to the regular PTO that employees normally get?
It's a great question and a great highlight for making sure that you guys go back, make sure you get these slides and take a look at them. And before I even go into that, because I know Tamir just said there's lots of questions and you haven't been able to, we're not going to be able to get to all of them unless you guys want to hang out with me for the 4 hours I promised you. Email me if you have follow-up questions. We don't get to your questions, but on to the actual question that Tamir started with. So as I mentioned, you can take your existing PTO and make it conform with HIFWA, the requirements of HIFWA, right? You just have to be really careful in doing so for two reasons. One, you need to make sure you're meeting every single one of those statutory requirements I talked about, how fast it accrues, what it can be used for, how much of it rolls over, how it's paid out, what benefits are available. But two, the one I want you guys all to think about if you're considering doing that is the fact that if you have a combined policy, a PTO policy that includes HIFWA-related reasons, you have to pay out any accrued but unused balance at the time of termination when an employee leaves your company. And for a lot of companies, they've navigated this historically by having waiting periods or having things accrue slower or something along those lines. And all of those are off the table now, right? So you do have those employees who only work for you for a short amount of time and then they leave. So the short answer is, is it in addition to what you already have? That depends on how you draft your policy. Can you have it incorporated into an existing policy? Yes, but if you do so, you have to be very careful, or else you're going to end up paying people a bunch of stuff and then have violations of this law anyways.
Thank you, Beth Ann. Let me mention to the crowd, we have our slides will be available to everybody. They're available in the handout section. We will also have the video put up to answer a few questions on our website within a week or so. So you'll be able to review anything you want to see again or watch again, and then follow up with any of us for questions. In addition, both the Employment Department and the OSHA team do their own additional seminars covering a lot of these issues. Yes, they will be holding them in 2021. I'm putting that out there. So make sure you participate in those and make sure you get the invites when they come. Okay, so next question. This one is for you, Jessica. And what are the pros and cons of having an indemnification for first-party claims as opposed to relying on just breach of contract claim?
So and this is something that I didn't get into with the slides, but typically when you, one of the reasons that you wouldn't maybe put the first party indemnification in there is that a lot of times you can rely on other provisions within your contract and it might actually be more available. But if you want to make sure that you can kind of utilize the framework of the indemnification and ensure that you have the duty to defend and all of those things, that might be one reason that you're going to want to use the first party claim and the first party to include the first party within your indemnification provision. But typically it is going to make more sense for you to put that in some other portion of the contract, maybe in some sort of limitation of liability or something like that. So that's kind of it typically is going to be in some other version, in some other portion of the contract, because it does make more sense to go outside of that indemnification and kind of leave indemnification to the third party.
Thank you. So we only have time, and we want to be very cognizant of everybody's time. We greatly appreciate everybody coming, so we have time for one more question. This one's for you, Jay. Is the premium cost driving up the value of claims, or are the claims driving up the price of the premiums? It's so expensive to litigate, people have to avoid it driving up the cost when it becomes necessary. Sorry, it was a double question there.
No, that's a, sorry, I cut you off. Yeah, I think it's the latter. I think the claims are driving up the premiums. But you point out, of course, that it is so expensive to litigate now. And so that's why when you're thinking about contracts, to go back to kind of, I guess, Tamir or even Mary Sue's discussion, litigation avoidance, one of the things that you should be thinking about is alternative dispute resolution provisions in your contracts, whether it be mediation before you get to litigation or arbitration. And then when you consider an arbitration provision, is it a very limited scope kind of arbitration that proceeds quickly so that you can resolve these disputes quickly? The counter to that, of course, is that every time you limit your options on dispute resolution issues, it's possible you're going to come into a situation where you're not getting all of the relief that you think you're entitled to when someone engages in acts that breach contracts and cause you harm on projects. So it's a balancing act for sure, but what insurers like is anything that would result in a more efficient effort to resolve disputes. But again, so much of this is going to be industry driven. Your ability to impact those premiums is probably going to be somewhat limited, but it sure doesn't hurt to try.
Thank you, everybody. We really appreciate you staying with us. We appreciate you coming in these times. We really look forward to being with you guys in person, hopefully sometime later in 2021, but if not, definitely as we do continue our annual seminar next year for its hopeful normal format, in person, full rapid fire session. Thanks again for everybody coming. Thanks for our panelists. We really appreciate it. Look forward to working with everybody together. Have a great day.
Thank you.